CFO Patronis, and the Department of Financial Services in this case. They are the appellants. Also joining us at council table is Chastity Osteen, who is the general counsel for the department. I would like to reserve 5 minutes for rebuttal, if I may.
Very good.
Your Honors, you have before you to review an order that invalidates as facially unconstitutional, a law that was unanimously passed by the legislature in 2016, designed to remedy some long-standing life insurance industry practices through which insurance companies were systematically keeping, I can't sugarcoat it, but they were not paying life insurance proceeds to the beneficiaries who own those proceeds. Neither were the insurance companies complying with the Unclaimed Property Act and remitting those funds to the state as unclaimed funds. The state, which of course through its police power can reasonably take custody of those funds for the benefit of the rightful owners, the individuals, the beneficiaries, who are the ones with the vested property rights in those funds. If
I could clarify, so when it's sheets to the state has a continuing obligation to look for the beneficiaries?
It does. And Chapter 717 sets out not only the responsibilities of entities like the insurance companies who hold unclaimed funds, but it also sets out the state's responsibilities to also, once those funds are remitted, then to also engage in its own search for the apparent owners of those funds. I'm sure you all have seen the unclaimed property website that the Department of Financial Services has. So that's part of the state's responsibility as it pertains to finding the rightful owners of those funds. The trial court ruled that to the extent that the legislature directed retroactive application of the amendments, and I'll just refer to them as the amendments, to Section 717.1071, that despite the fact that there is express direction from the legislature that the amendments are remedial, designed again to address and resolve the longstanding industry practices, and despite the fact that the legislature has designated expressly that the amendments should apply retroactively, the court ruled facially unconstitutional. There are several.
Let me ask you a question, because a very, very basic question on this case. Is the argument that we should allow it, or the court should allow it, even though it's retroactive, as the legislature said, or that it's not really retroactive? Because I kind of seen both arguments being made here, that what's really being requested is not retroactive application of the law. It's installing new requirements on the appellees that may refer to something that happened in the past, but it's not retroactive. Is there any, I guess my basic question is there any dispute as to whether the law applies retroactively?
Your Honor, that is the dispute, in fact, because...
So your argument, I'm sorry, is that it does not apply retroactively?
The CFO in the department position is that yes, the law does and can and should apply retroactively because it is remedial and because it does not impose any new legal consequences, it does not impose any new penalties on any events that have occurred in the past or any transactions that are complete. And for that reason, it can apply. It meets the definition of remedial legislation. And we know that remedial legislation comes out from under that prescription against retroactive activity. Now, the trial court, and I may as well put it out there, both the trial court felt, and it's clear from the trial court's order, considered itself limited by and bound by this court's 2014 decision in the Thrivent case. And that decision also really gave rise to the amendments that we're talking about today. Now, to sort of answer your question, Judge Winokur, not only are we asking this court to consider the amendments for the remedial nature and to agree that they apply retroactively, but we also suggest to the court and submit to the court that because the amendments were enacted, again unanimously, were enacted so closely in time to the Thrivent decision and directly in response to the Thrivent decision, that this court can and should look at those amendments as clarifying legislation and as informative, shall we say, about the legislature's original intent as to how
The legislature's intent when it passed, I don't have the statute, the 717 statute originally,
Yes. Now,
which was not a year or two before the 2016.
It was not. Courts can, and legislatures do this all the time, do pass clarifying legislation, and courts can, and as the Second District recognized in the Madison at Soho 2 decision, courts have a right and a duty when legislation is passed so soon after a controversy arises as to the interpretation of the original legislation. Now, yes, we recognize that there has been some time between the original enactment of the unclaimed property law and this clarification amended, or the amendments passed in 2016. But the controversy, which arose over the interpretation of the original act, didn't happen until 2014, until this court's decision. Now, we are not here
And that was
to
done
re-argue that
because
case.
the department issued a declaratory statement. So
Correct.
basically it had been interpreted that due and payable was when, for lack of a better phrase, when the insurance company found out about the death of the insured. And then, well, the department says, no, we're going to say it's at the time of death and not when they found out. So to the extent that it had always been interpreted the prior way, and then the department just sort of said, no, we're going to interpret it differently from now on.
Your Honor, I would disagree with that characterization. The controversy over the interpretation arose when that petition for declaratory statement was filed. The department interpreted that provision as meaning appropriately that the beginning of the 5-year dormancy period for life insurance policy proceeds begins at the date of death. Prior to that, there were no controversies over that application. And it was at that time then that the department's declaratory statement was appealed to this court. And then this court came out with its decision in Thrivent. So it's not that previously there was some controversy over how 717-107 would be interpreted. The legislature and the department had always interpreted that way, and it wasn't until the petition for declaratory statement that it came into question at that point. So that's really where the controversy arises, and this court's decision. But
Yeah, and this court resolved it, and it didn't say, well, we recognize this is an ambiguous statute, could go one way or the other, and we're going to rule for the insurers because of rules of statutory construction. No, what we said instead was that the department's interpretation was clearly erroneous and was contrary to the plain meaning of the statute. I mean, how can we ignore that? How can we say that something that changes the law was really just clarifying the law when we had said that the department's interpretation was completely contrary to what the law said?
Well, Your Honor, the legislature is always within its authority to, if a court has interpreted a statute that it has passed in a way different from its intent, it has the authority to pass clarifying legislation to say, no, we intended for this statute to be interpreted this way. But we also have, the clarification didn't come out of the blue. This isn't a question of a legislature in 2016, saying we know what the legislature intended in 1987 when the Unclaimed Property Act first came about. We have you know, we have the Connecticut Mutual versus Moore case that's been around since 1948, when all of this, when unclaimed property laws first started to come about. In that case, we know that the U.S. Supreme Court said, look, for purposes of taking custody of unclaimed property, the state, it is unreasonable. It would be unreasonable for the state to be held to require the same kind of paperwork that a beneficiary would have to submit under the terms of the insurance contract in order to receive those funds as unclaimed. It would be unreasonable. So there's that. There's also the longstanding law in this state that a life insurance policy becomes a claim on the death of the insured. That's when the obligation to pay arises. And the remainder of that statute, which I believe is 627-461, says, you know, the policy becomes a claim by death of the insured, then settlement shall be made upon receipt of due proof of death and surrender of the policy. Now, respectfully, I'm not here to argue or to re-argue Thrivent. That is not the intent, because the legislature has already enacted the amendments in response. But when you look at that, and you look at, you know, the Unclaimed Property Act, after which our own act is patterned, when you look at the entire statutory scheme in Chapter 717, which I don't believe was in front of this court in Thrivent, when you look at the entire statutory scheme and how that all plays, one can only conclude that the legislature enacting the amendments in 2016 completely understood what was intended when the Unclaimed Property Act was enacted initially.
You know, to me, as I look at this case, trying to look at it at a larger level of abstraction, the state says, we don't like what's going on, so we're going to come in and we're going to tweak this part of the statute. We're going to put in a period of 5 years in which you have to comply. And it seems like what they were trying to do is almost like a consumer protection agency would do, which is to say, we have a problem, we want to correct it, and here's how those affected by the agency action are to operate, both prospectively and as to existing contracts. There's no contract clause claim in this case, number one, right?
No, that
okay.
was dismissed below by the insurance companies.
Okay, so the claim boiled down to, well, you're putting new obligations on us that there's no statutory authority for, and they're being applied retroactively and they're burdensome and all that. But is it always the case that when the regulatory agency of the state and the legislature puts some additional obligation on a business, that somehow, oh, no, we don't have to do that. All the small businesses are going to go out of business. The big ones, you know, might have to have more expense. It seems to me that there's a level of analysis that I'm not quite getting in this case. Because as I looked at the statute before the Chapter 2016-219 was enacted, it says, as established from the records of the insurance company. Well, I'm not sure exactly. I'm a judge. I don't know what that means in the industry. I guess I can figure it out by reading the briefs and so forth. But it seemed what the agency was trying to do was clarify that.
That's certainly what the legislature was doing.
I mean, that's your position, is that we want to make this clear, because we thought it was clear, but the first district didn't agree with us. So we tried to change it. Why can't I guess maybe that's a question for when they get up here. Is there just, they just can't do that, period? It's like the trial judge here said, there's a new burden, you can't do that? Or is there some sort of rule of reason in play here?
Are you asking, is there some reason why the trial court could not have read this, the amendments as clarifying legislation? Right.
I mean, call it what you want. It was basic. I mean,
it could have. And in fact,
the legislature said it's remedial and it's going to apply retroactively. They made that entirely clear.
right.
That didn't get you all the way around the bases to home plate, but that's strong indication of what the legislature thought this was.
It is. And the trial court, like all courts, had a duty to first, accord that legislation a presumption of constitutionality and to uphold it wherever, if it's possible at all to do that. To the extent that the legislation is remedial, expressly remedial, this is the cases that the trial court relied on are all cases, of course, from other jurisdictions setting Thrivent aside, there are cases from other jurisdictions in which the constitutional questions weren't even addressed, first of all. Secondly, at least two of the cases involve, statutory construction questions. Though those courts were dealing with statutes in which there was no legislative expression that the statutes should be applied retroactively. And so those courts resorted to, those canons designed to discern legislative intent. That's not what we have here. We have expressed legislative intent. The amendments are expressly remedial. They can be constitutionally retroactively applied. The duties that the insurance companies say they never had have existed at least since 1987 throughout the statutory scheme of Chapter 717, and therefore the amendments are constitutional. They're certainly not facially unconstitutional. I'd like to reserve the remainder of my time.
Very good.
Thank you.
May it please the Court, Carolyn Thompson of Sidley Austin and Hope Keating of Greenwood Trowbridge, on behalf of the appellees in this matter, United Insurance Company of America, the Reliable Life Insurance Company, Mutual Savings Life Insurance Company, and Reserve National Insurance Company. We ask that this Court affirm the trial court's decision awarding summary judgment to appellees and enjoining retroactive enforcement of the Act. This Court should affirm the trial court's decision finding that retroactive enforcement violates the Due Process Clause of the Florida Constitution because the Act imposes new obligations in connection with previous transactions or consideration.
Well, I guess that's kind of my problem of how we even define retroactivity. I mean, obviously, the legislature can put burdens, can put requirements on insurers, for instance, and you may not like them, you may think they're great, but that's not the issue here. The issue is not whether these are proper requirements or whether they're constitutional, other than the fact that they are applied retroactively. And I'm still struggling with what it means to apply them retroactively. To me, if a requirement is being applied to something that already exists, that doesn't make it retroactive. And I was thinking about what would happen if the legislature decided to require a hands-free device for every car. Could somebody come in and just say, well, I already own this car, so you can't require me to get a hands-free device because it's retroactive. Now, some of these claims that I see the insurers making kind of remind me of that. They don't actually change any obligations that the insurance company has with regard to the insureds. They just simply put new obligations, which you may or may not like, on the insurers. So try to explain to me, if you don't mind, why it's actually being applied retroactively to, I don't know, something that you have a right to that is being altered by the new amendments.
I actually think that a couple of the cases that were cited extensively in our briefs, in particular Maronda Homes and Menendez and State Farm, both Menendez and the State Farm case involve insurance contracts.
And what I notice about those is those involve certain damages. So in other words, it has to do with the policy, and you sue on the policy, and what damages can or can't be sought by the insured. That strikes me as something that affects the insurance contract itself. It affects the terms of the contract. I don't necessarily, I'm not saying that we don't have that here, but I want to know whether that does exist here, whether there is something that is impairing, I don't want to say impair the obligation of contracts, because obviously that count was taken out, but that impairs it to the extent that it's retroactive.
Yeah, so if I could first address the question of whether it's retroactive and whether it affects previous transactions. So in Menendez, you had a PIP requirement, a pre-suit notice requirement. And in Menendez, the court says, first we've got to start and look at whether this is retroactive. And we're looking at, there are a number of alternatives that can make this retroactive. It could be when the policy was issued. It could be when the accident occurred, or it could be when the claim happened, or it could even be when the suit was filed. And the court said for the insurance transaction, the transaction happened when the policy was issued. And so for here, what we would say is the transaction at issue is a policy that was issued. And so the nature of the retroactivity here is that it affects all in-force policies, policies that already were issued, and policies that were issued any time from 1992 to the present.
How does it affect the policies?
Pardon me?
How does it affect the policies?
And so it changes the fundamental legal obligations. And so, as we pointed out, and consistent with that insurance code section, which the First District relied on in Thrivent, 627.461, it says that insurance companies pay when somebody comes forward with proof of death. And that is not unusual in the insurance context. All insurance happens that way. The insurance company pays a claim when the person who's entitled to the payment comes forward. And what the statute does, which is fundamentally different, and which is what the legislature itself said affected a paradigm shift, says that every year, I think it's twice a year, that for every single policy an insurance company has, they have to go and affirmatively take the names, dates of birth, and Social Security numbers of all those policies, compare them against the Social Security Death Master file, and look at things like John versus Jack, Thomas versus Tom, and see if you have a match. And then if you do, the obligation's on you, the insurance company, to find the beneficiary, reach out to them, and say, we think you need to make a claim. And then it also says that you need to figure out if these deaths occurred, because for every single one of these policies that were issued from 1992 to the present, that could be a policy that was issued in 1980 and that was in force in 1992, you need to go back and figure out if a death occurred, because under the state changes to the statute, you now have an obligation to escheat that property 5 years from the date of death. So from the insurance company's perspective, yes, this is a fundamental change in the way they do business in the life insurance context. They don't wait for the beneficiary or someone in the family to come in and say, you know, my father died, my mother died. Now twice a year, every year, they've got to go out and try to figure out if anybody in their entire portfolio of life insurance policies has died. And so the insurance companies...
With that argument, though, I mean, procedurally, that might tell you, yes, you have to hire more staff to go back and look at and see if it's due, but shouldn't we be looking at a qualification of, for example, eligibility or right to payment being separate and apart from, when those benefits are payable? So if I think the strongest argument here on the substantive level is the dormancy change, the 5 years, but doesn't that 5-year change, doesn't it affect when benefits are payable, quite frankly, as opposed to a right to the benefits or payment, such that it's a procedural change, is a strong argument?
So there's two things going on. There's the right of the beneficiary to payment, and then there's the state's right to escheat the unclaimed property. And so what the trial court found is that the state's right to escheat was fundamentally changed, because it created the state now has a right to escheat upon the death of an insured. Whereas, as this court found in Thrivent, looking at the plain language of the statute, there were essentially 3 circumstances where the state could escheat unclaimed property. First, where a policy was matured by proof of death. That's where somebody comes in and hands a death certificate. Second, it said the policy could be escheated where the insurer had knowledge of the insured's death. So this is like the Connecticut Mutual situation, where we didn't get a death certificate and the state isn't giving us a death certificate, but the insurance company has knowledge of death. And the third was where the insured attained the mortality limiting age, or would have attained if living. And as the court pointed out in Thrivent, that language that says, which is another third example where the state gets the right to escheat that property even though death benefits would not be payable to the beneficiary, because the mortality limiting age is like a presumption of death. Under most of the policies at issue, that would be age 100. And so under the state's unclaimed property law, it said, when your books say that somebody has not made a claim and this person is 100, the state has a right to escheat that property. So those were the 3 circumstances where the state had an escheat right. And as Your Honor points out, what the statute does is says, no, now, anytime somebody dies, 5 years later, the state has a right to escheat that property. So it changes the state's rights and it changes the company's obligations, because this whole rubric under the unclaimed property law, they now have a new reporting obligation. They have a new obligation to go out and find, particularly for all these policies back from 1992 to the present. They've got to figure out if somewhere they didn't get a claim, that they didn't have knowledge of death, and that somebody died while the policies was in force. And so that's the escheat piece of that, where the trial court said, yes, this really imposes a new escheat obligation. And that following Thrivent, which said, no, your escheat obligation was limited to these other three circumstances as set forth in the language of the statute. And that's why we also pointed to other cases which have said that kind of change to an escheat obligation is substantive and not remedial. And so there was both the United Insurance case in Kentucky, where the court said, this kind of change that you make to the dormancy trigger and imposing this comprehensive DMF search obligation, those are not remedial changes, those are substantive changes. And then also the American Express case, where American Express came in and said, okay, you've changed the dormancy period for traveler's checks. They used to be 15 years, you changed it to 7 years. And the Sixth Circuit said, that is not a remedial change, that is a substantive change. That gives the state a new right to escheat unclaimed property, which it didn't have before, at 7 years instead of 15, and it changes the obligations of the traveler's check issuer as well. They've got to do something different at 7 years. They don't get to hold on to that property, invest it, whatever, for 15 years. So that's a substantive change. And we pointed to two other cases that made that same finding. There was the Biogen case and the Empire Resources case. And those two cases in Massachusetts and Delaware likewise said, if you change the dormancy period, that's a substantive change to the law and the obligations of the person holding the property and the state's rights to take that property. Same thing in Biogen. If you change the circumstances pursuant to which you escheat property, that is a substantive and not a remedial change.
Can I ask you a question, counsel? Is there any problem with applying these requirements from your perspective to active policies? In other words, policies that are currently being paid where there's no question that the insured hasn't passed away?
Yes, Your Honor. We're making a facial challenge, and so it is our position that if a policy was in force on the date that the act was enacted, that policy, that transaction already occurred, and so that it cannot be applied to a policy that already was in force. But we're not objecting, and we certainly agree that consistent with the state's ability to, under its police power, to have remedial legislation on a general term, as it's used in the statute, it can impose these obligations on all policies issued as of July 2016, absolutely.
So it's facially valid?
Facially invalid.
No, it has to be facially valid, but we're just not going to apply it retroactively.
Oh, I see what you're saying. So the retroactivity piece of it is what we're saying is facially invalid.
Right, but didn't we also say that you determine retroactivity by the time that the contract is executed?
Yes. So to the extent that that clause itself in the statute itself, the act says we are applying this retroactively to all policies now in force and that were in force at any time from 1992 to the present. And the statute
So it's
says,
really an as-applied challenge. It's as applied retroactively.
No, Your Honor, because if you look at the cases that talk about as applied and a facial challenge, so we're not saying there's a particular set of facts. We're saying that language, the retroactivity clause, that entire clause that says the statute applies retroactively to policies in force from 1992 to the present, that entire clause is facially invalid. We're not saying that there are some circumstances where some contracts are subject to that. And so when I've looked at some of these cases dealing with as applied versus facial, the question is, it doesn't require you to say the entire act as passed is valid. You can say that this piece of the act, as applied to anyone that is subject to it, would be invalid and constitutionally suspect, and that's what we're saying.
Where does the judge's order say what you just said?
Pardon me?
Where in the judge's order does he say that the provision of the law of 2016 is facially invalid?
The judge, at the end of his opinion, says that this is a.
I mean, maybe there. I'm just looking for it.
He did
Help
make
me
a
out.
finding that it was facially invalid.
Facially invalid as
The
applied to
retroactive
existing.
clause was
Yeah.
facially invalid.
Which sounds like as applied, but.
He says retroactive application of the amendments is hereby enjoined. Is that what we're talking about? I mean, it's got to be facially valid if you're not contesting that they can enforce these obligations prospectively. So it's facially valid. They can do that. They can do what the law says prospectively. But what the judge has done is said, well, that's fine and dandy, but I'm not going to allow retroactive application of it.
I think what he was doing is he was striking down the retroactive piece of the amendments. So, you know, the amendments could have various different provisions, and you could say, well, we're not challenging, I don't know, some other minor piece of it, but to the extent that it says, as to all of these contracts, it applies retroactively, then yes, we are saying that that is invalid, that retroactive piece of it.
Just thinking out loud, why wouldn't there be, and I'm just thinking out loud, maybe
Yes.
that's dangerous, but why wouldn't this case be better postured as saying, well, there's certain categories of these contracts to which it would be very onerous, and as applied in those situations, there'd be burdensome and be a due process violation, because it creates this new owner's obligation. I mean, it certainly doesn't prospectively, that it's okay. Everyone's going to comply with this law prospectively. Why wouldn't this just be better to look at this as where does this really impact negatively within the industry, rather than facially saying everything retroactive, it's out of here. It's violated due process. Can't do it.
Well, I think if you look at the Supreme Court's jurisprudence in this area, where they're looking at retroactive application of statutes, and even ones that say, like here, that this is being applied retroactively, as in the case we looked at State Farm, Menendez, all of those, they appeared on their face to say, oh, we're going to apply retroactively to enforce policies, and the court said, regardless of that, you have to look at whether it can be applied retroactively, and we're saying retroactive application across the board to any policy that already existed is invalid. So it's the
Let me ask you this
retroactive
question.
application.
Let's say that this law, and again, this is hypothetical, so I don't have to concede anything, but if the law imposed a very minor administrative obligation on insurance agencies that would raise policies, 10 cents over the life of the policy. So just a minor ministerial thing you have to do with your computer system, whatever it is. And we want it to be applied retroactively, we the legislature. Does that get thrown out as well? Or is there some sort of sense that you have to look at the record and say, well, this is a really big burden. It really imposes these obligations on us that are in violation of our due process rights?
Yeah, I think it would depend upon whether it was a substantive new obligation. It sounds like it's a new obligation, and it sounds like it's a completed transaction here. You're saying it's a policy that already was issued.
I mean, I'm just saying, it seems to me common sense that, okay, they put this new obligation on you, well, how onerous is it? Not onerous at all, well, it's okay, it's due process, it's fine. It's a substitute, or procedural due process, or here we're just due process, I guess. But if it's a really onerous obligation, then it may be problematic constitutionally. Isn't there some balance to be done there? And was that done in this case?
So what the court has said, when you're looking at what is remedial or procedural, you look at whether the new requirement under statute is meant to enforce an existing obligation or to further an existing right. And here, what we're saying is that the escheat obligation is fundamentally changed. If you look at what happened, that the state didn't have a right to escheat policies just because somebody died. And the court in Thrivent said that too. You don't have a right to escheat under section 717.107 just because somebody died.
If I look through the judge's order, I can't find where he says why. It says it's burdensome, it changes your obligations, but I don't see where there's a finding as to how onerous it is and how this is going to be cataclysmic within the industry. I guess there's a amicus brief and so forth. But shouldn't that be part of the analysis or not?
Not, at least not from what I've seen in Miranda Homes or in Menendez or in State Farm. The question really is it a new legal obligation, and does it fundamentally change? And here, as we pointed out, it's not just the state gets a new right to escheat unclaimed property, but there's also new obligations imposed on insurers to go out and do these DMF searches, something they had no obligation to do in the past, because now they've got to go out and gather up all
Let's
these.
suppose that search is fairly minimal. We're in the computer age now. The statute was passed in 1987. We're now, 30 years down the road. And the search techniques the insurance companies use, I'm sure, are much more sophisticated. What's wrong with that additional obligation to do this, to check this list? It's almost like a voter, let's check it.
There's nothing wrong with that on a prospective basis.
Okay.
But there is something wrong with that on, and taking
Well,
the
why wouldn't you
contract.
do it anyway as a good business practice? That's my question.
People might do it as a good business practice, and they're entitled to do that as a good business practice, but coming in and mandating that insurers do that
Well,
is
they have to do it prospectively now. I mean, every insurance company has to do that now
on a
prospectively.
prospective basis. Yes.
Okay. So they're going to carve out the past and not do it, but do it for all the other policies prospectively.
Yes. As a matter of law, yes, that's what we would say. And then I also wanted to address the argument that the state made about this being clarifying legislation. And as we pointed out in our brief, we don't think it's clarifying legislation. First of all, as this court already found, under the plain language of the pre-existing statute, there was no dormancy trigger at the insured state of death, and there was no obligation to conduct DMF searches. And in fact, the legislature didn't believe it was clarifying the legislation. There's no statement anywhere in the legislative intent that the legislature is clarifying its intent. On the contrary, the statements that the legislature makes in the title of the act and in the act itself reflect that it doesn't believe it's clarifying. It says it is amending, it is revising, it is implementing a new requirement. And the Senate staff bill analysis says the same thing. It says they are acknowledging this will impose new costs on insurers, that it substantially amends the act, and it revises the conditions pursuant to which funds are considered due and payable, and when funds are deemed unclaimed. So there's nothing in the legislative history. To the contrary, the legislative history reflects that it's changing the law, not clarifying it. So with that, I request that you affirm the trial court's judgment. Thank you very much.
Thank you.
Your Honors, I'm going to address that last statement first. I'm looking at the final bill analysis for committee substitute to House Bill 1041, which ultimately became the law that we're talking about. And it states in actually two places that, quote, the legislation clarifies that life insurance proceeds may become unclaimed property even if the beneficiary of the policy has not yet filed a claim for the death benefits with the insurer, and that the dormancy period for life insurance commences upon the date of death of the insured. I don't know how much more clear that can be about what the legislature intended as to the clarifying legislation that
Well, let
it
me
has
ask you,
here.
Counsel, let's say you're right. This is a clarifying statute. It was done in direct response to the Thrivent case, and it was meant to control what the statute really means. What does that mean for our case? Does that mean that, we are to interpret everything back to 1987 exactly as the 2016 legislature wanted? Is that what it means to call it a clarifying statute?
Your Honor, what it means is the legislature has clarified its intent on how that provision should have been interpreted in the first place. Remember, we're now applying the amendments, not the prior law. And so to the extent that this is clarifying legislation, we don't have a retroactivity issue. Clarifying legislation doesn't generally come under that kind of analysis. And so to the extent that the legislature has said, we're clarifying this.
Can they clarify
This
it
is
to
what
make
we
it
intended.
retroactive?
Pardon?
Can they clarify it to make it retroactive, which is kind of what
Well,
I'm
I mean-
understanding from the appellees?
I understand, Your Honor, legislative drafting isn't a perfect science that we know. But from the state's perspective, even if this court doesn't agree that the amendments are clarifying legislation, to be sure it's remedial and expressly allowed to be applied retroactively. Another thing I wanted to point out to the court, what you've heard from the insurance companies is a lot about our contractual responsibilities. It's contract. Yeah, they have contractual responsibilities, but the reality is that the transaction for which the insureds contracted is not yet complete. It is not complete until the beneficiaries are paid or the unclaimed money is remitted to the state. And that's the key issue here about the substantive versus remedial thing. Whether or not this, if you were to arguably look at this, the amendments and say, well, these are, substantive, like the trial court did, that doesn't matter. We know that in Florida, substantive laws can be applied retroactively so long as they don't create new legal consequences for events or transactions that have previously been completed. That is not the case here. This is a curative statute. It protects the interests of the insureds and their beneficiaries. The issue is not about the contract. The issue is about the responsibility under unclaimed property laws.
So if I hear you correctly, retroactive application may be impermissible as to a certain classification of these contracts, but not others. In other words, ones that have been fulfilled and there are not.
Your Honor, no.
No, okay.
That absolutely is not the state's position. The state's position is, there are records out there that simply need to be searched to determine whether the insurance companies have wrongly held onto insurance proceeds that should either be paid or escheated to the state. And I think you heard a statement that Thrivent held, basically, that the state has no right to escheat these funds at the time of death. That is certainly what that is not what Thrivent held at all. Thrivent was about the beginning of the dormancy period. It begins at the date of death, which is the date on which the insurance companies owe that money to the beneficiaries. Thank you, Your Honor.
Very good. We appreciate the advocacy today. We will be in recess.